Good morning, everybody. Thanks so much for being here at our virtual clinic this year. We're really excited to have everybody. We're doing a little bit different format than normally you would have like at an in-person clinic. So for the first hour, we're all going to be together and go through some stuff together, and then we'll break out between the beginners and the more immediate, intermediate, and advanced students. With me today, I don't know if they want to turn on their cameras, but helping today, we have Jamie Olin, Electra Watson, and Stacy McNulty. All four of us are practicing attorneys, and we've all previously been involved with high school mock trial, helping run an organization at least. Not all of us actually participated in high school mock trial. I am a co-vice chair of the mock trial committee, so that means I actually help run a lot of the background stuff that affects y'all's day-to-day lives in terms of the competition. I help write the problem, things like that. And so we're excited to be able to host this clinic virtually. Some of us are live from the Dallas area, and at least one of us is live from not the Dallas area, from another state entirely. And so that's pretty cool that we can still all participate. And I'm sure some of you, I know some of you are from parts of the state where you would not be able to attend our in-person clinic. I know there's some people from the Valley and other parts of the state. And so we're excited to have all of you here to be able to give you just some guidance and pointers and tips for this mock trial season. So Jamie, I'm going to start my presentation. I cannot see the chat when I do that. Do you think you can monitor chat for me if needed?
Yeah, absolutely.
Okay, great. Okay, so the first part, I'm just going to do like a brief overview of some of the, not necessarily the most important rules, but some of the rules for the actual presentation of your case that are really important. There are a lot of rules that affect who can participate in mock trial, things like that. I'm not going through all of those today, and I'm not even going through all of the rules, but we just wanted to point out some that we think will help you as you're preparing so you know what to focus on and think about, okay? So first, I just want to highlight that there are a lot of really specific rules for your timekeepers. These are really important. Make sure your timekeepers know the rules backwards and forwards, that you have a designated timekeeper. And most importantly, if you don't have a designated timekeeper, you're going to be bound by the other team's timekeeping. So it's really important that not only you have a timekeeper if you can, but maybe one of your alternates is also trained in timekeeping as a backup, because we run into that a lot where sometimes the team doesn't have a timekeeper and then they don't think the timekeeping is done correctly. You're sort of stuck in that situation. So read those rules really closely and make sure you understand them, and make sure you have a timekeeper if you can, okay? The problem consists of 3 witnesses per side, all of whom have names that either gender can play. All 3 witnesses per side must be called, and teams may not call any of their own witnesses a hostile witness. The other part of this rule that's important is that you must call all of your 3 witnesses. You cannot call the other side's witness. So there's no clever strategy to be had here where you can call, like the plaintiff can call a defense witness or vice versa. The plaintiff calls the 3 plaintiff's witnesses, the defense calls the 3 defense witnesses, but you can call your 3 witnesses in any order that you want to, okay? Witnesses are bound by their own statements, the written statements and the addendums that are in the problem. You may make fair inferences from the information and may add immaterial facts, such as, someone's hair color, if that's not a material fact. But it has to be consistent with the witness statement. Okay, you can't create a material fact. When we talk about a material fact would be something that affects the ultimate question of the case. So as long as it doesn't affect the ultimate question of the case, a witness can have a fact that's maybe not material. Though you may not have time to get into stuff that's immaterial to the case. So, I would caution you not to spend a lot of time trying to think of some ways to jazz up a witness or to make something more fun or colorful.
Jessica, if I can interrupt you for a second, we do have a couple of questions.
Okay.
So the first is, what's the maximum number of people you can have on a team?
The maximum number of people you can have on a team is 10. So that would give you 3 attorneys, 3 witnesses, a timekeeper, and 3 alternates. That's how many people can be on the roster. Now, sometimes you can have more people on the team generally, but your roster itself can only have 10 people. And I believe this year, because of COVID restrictions, you may not be able to have people who are not on your roster attend in person, at least for if you're in the Dallas area attending our rounds in person.
Great. The other question is, does it have to be the same student as timekeeper throughout the competition?
No, that's a great question. You could have a different timekeeper. So some teams will have different people play different witnesses. So if you're representing the plaintiff on one side and one of your alternates is the timekeeper, but then that alternate's a witness for the defense, you could switch timekeepers. It doesn't have to be the same person. You just have to have a, we just recommend you have a timekeeper throughout.
Okay. And then one more came in, which is, if there are alternates, can they sit in the trial or at the courtroom?
As long as they're on the roster right now, yes, that is my understanding. Again, because of COVID restrictions, we may not be allowed to have a whole lot of additional people in the courthouse when the competition is happening. And so as we have more information about that and know more about the restrictions, Melissa will reach out to all of the coaches and all the teams to give you more guidance on that.
And then one more, what's the minimum amount of people we need and the essential roles that they need to fill?
You absolutely have to have 6 people. You need 3 attorneys and 3 witnesses. If you don't have a 7th person to be a timekeeper, like I said, you'll just be bound by the other side's timekeeping, but you have to have 3 witnesses, 6 people, because you have to have 3 different attorneys and 3 different witnesses.
Great.
Those are all good questions. Is there anything else?
I think that's it.
Jessica, the one thing I thought it might be worthwhile just to mention, in case there are interested people, is the courtroom sketch artist. Is that happening this year?
I believe it is still happening. I think that process happens a little bit differently than this particular process. It's technically a separate competition that just runs at the same time.
But they don't count as a team member, right?
Right. They're not going to be on the roster. They're not listed anywhere specifically. They would be registered separately, I believe.
Cool. Thank you.
That's a great question though, Stacy. Okay. Sort of in line with the previous rule about witness statements, there is a rule against unfair extrapolation. A fair extrapolation is one that is neutral. Unfair extrapolations are best attacked through impeachment. Closing arguments are to be dealt with within the course of the trial. That second part is what I want to highlight, being dealt with within the course of the trial. While it's technically a rules violation to have unfair extrapolation, if you wait until the very end of the trial, and Jamie, I know you've presided over a lot of cases, and someone waited until the very end to make an objection on unfair extrapolation, we're not going to remember what was said exactly or what the witness specifically said. You need to be doing it as it goes along if you genuinely believe someone's unfairly extrapolating. And so just a really basic example of that I came up with is, if a witness statement says that a witness graduated from college with with a degree in biology, it's a pretty fair extrapolation if the witness then says, well, I went to college for 4 years, right? Most people go to college for about 4 years to get their degree. What might be unfair is if the witness then starts to say, well, they have a master's in biology or they have a PhD. If the witness statement doesn't say that, adding things that would increase someone's credibility or background or things of that nature might be pretty unfair. And that's like, pretty egregious example. I think most people would notice that that's happening. But if you think unfair extrapolation is happening, you should be objecting as it's happening and having a conversation with the court at that time. You can also, again, handle it through impeachment by impeachment would be, asking the witness on cross-examination, well, that doesn't match your witness statement, does it? Things of that nature. I just wanted to highlight that you really need to be doing that during the trial. That's not really a rules violation you want to bring up at the very close of a trial, because by then it's probably too late to be handled in a way that's going to be satisfactory to people. Okay. Team compositions. So this was actually the question that was just asked, was how many people can be on the team. So we've already addressed this. And so just going to move on. Just as the tip for me as a scoring judge and presiding judge in the past, usually there's a pre-trial session where students are asked to introduce themselves. It's really useful if you also include in your introductions what roles you're going to be handling. So if you're an attorney, to say, I will be directing this person and cross-examining this person. That's usually very helpful for us to identify who you are, because every once in a while your rosters don't match up. So make sure your rosters are correct. And then it's helpful to do that in an introduction as well, so we know who you are and what your role is, so we can give you the credit that you're entitled to, okay? And again, we sort of already addressed this, but team duties, you're gonna have 3 attorneys. Each attorney does 1 direct and 1 cross. One attorney does opening and another attorney does close. So the same attorney cannot open and close. They have to be 2 different attorneys. Opening statements must be given at the beginning of trial. If you try to waive your opening statement, you just get 0 points for your opening. It's really what's going to happen. And even if the plaintiff tried to waive, the defense is still required to do it at the beginning of trial. Both sides must give an opening at the beginning of the trial, okay? Otherwise, you're just going to lose points and then you're not going to get anything for it. And an attorney who examines, and we say examine, we mean you're the person directing or crossing them. You are the only person who can make objections during that witness's testimony. So if attorney A is asking questions of a witness, attorney B can't then come along and make objections during the cross-examination.
And Jessica, if I can interrupt again for
Yeah.
a second, we're getting a lot of really great questions in the chat. So thank you everyone for utilizing the chat in this way. That's great. We're getting a lot of questions about objections, and it's my understanding you and Stacy are going to be leading the beginners group after we split into our separate groups.
Mm-hmm.
And I believe y'all will be covering objections in a lot of detail, right?
Yeah, I have a very briefly highlighted on the rules just to send you guys to the rule that is about objections, but we're gonna, at least in our beginner session, we're gonna do a little bit more detail about objections, how to make them, that sort of stuff. And I believe the intermediate and advanced will also be covering that if necessary, getting maybe into a little bit more detail on a higher level. But yeah, we're gonna cover objections in more detail during our breakout in just a little bit. So.
Great.
Is that what most of the questions are about, is objections?
Yeah, there's another question here. Any thoughts on whether it's better for the lead attorney to introduce everyone on the team or each participant to introduce him or herself?
I think that's up to the team. I like it when people introduce themselves. That's my personal preference. I don't know, Jamie, Stacy, Electra, I don't know what y'all's preference is.
Sometimes the judge will indicate what they prefer. That's presiding over the trial. So the judge might say, could the attorneys please introduce themselves? Or if the judge doesn't say anything, you know, one person can feel free to do it all. Just listen to the judge.
Yep. I agree with that. And I'd say the key thing is that the introductions are made at some point. For me, when I'm presiding, it doesn't matter if one person introduces everyone or each person introduces themselves. I just want to make sure I know who's speaking so that I know who I should be giving the points to and who I'm addressing.
Yeah, that's the main thing for me too, is so that I know who is doing what. Because if I'm going to pick an outstanding advocate or an outstanding witness, I'd like to know who you are. Because if I get to the end and I don't remember who this person is, you may not get that outstanding witness or advocate. So that's why it's always really helpful to identify yourselves clearly. Making sure your rosters are correct is also really, really important for that.
One more question. This is kind of a fun one. How aggressive can an attorney be on cross-examination of the witness?
I don't know. What do you guys think? I think you can be pretty aggressive if you think that the facts call for it and you think you have the questions for it. You can be pretty aggressive in a professional way.
Right.
Obviously, we're not going to be insulting. We're not going to be derogatory or any of those things, because you're going to lose points if you're doing that.
And also remembering that argumentative is an objection. So, I mean, you want to stay on this side of that.
Yeah.
Mm-hmm.
Yeah. And, also sometimes people think they're being extra aggressive when they're just asking the same question over and over. So you want to make sure you're not just being repetitive, because that's also going to get you some objections. But there are ways to be pretty aggressive and to really, attack facts, because sometimes we have witnesses who are they've got really bad facts that need to be brought out. And so, yeah, I mean, as aggressive as you feel like you can be is, if you think the facts warrant it.
if you think if by aggressive you mean control your witness, then yes, be aggressive. If by aggressive you mean be a jerk just for the sake of being a jerk, I would err on the side of no.
Thanks, Electra.
Everyone has their own individual style, and I think that everyone should embrace their individual style. Go with what works for you. Not you don't have to be a particular way to be a successful trial attorney.
Yep.
Yeah. And what you see on TV is not always the best way to be a trial attorney.
I would go so
Never.
far as
It's
to say
never
it's
the
almost
best
never
way.
the best way.
Okay, moving on.
This is a
Time-
good question.
Okay.
Quickly, sorry, it says, what are stipulations and how important are they to the case?
Stipulations are, oh gosh. I think I have that further in
Okay.
but if I don't get to it, remind me to come back to that one. Okay,
Yeah.
so trial sequence and time limits. This is set out in the rules. I think Melissa has also sent out to all the teams like a really clear breakdown of the sequence as well, where it's broken down a little bit more for you. The main thing to know here is that saving time on any of these particular categories does not increase your time for other categories. So if you only spend 4 minutes on opening, you've just lost a minute. And that's fine if your opening only takes 4 minutes, but you don't get that minute elsewhere. Okay, that's all I really wanted to highlight there. The other part of trial sequence, there's rule 4.22. You get 1 redirect and 1 recross. We're not going to redirect. We're not going to redirect. Direct, cross, redirect, recross, and then the witness is done. Okay. That just will help you plan strategy wise as you're listening and what questions you want to ask. You're not going to get 8 chances to talk to your witness. Okay. Let's see. Motions are prohibited during the trial. We're not hearing any sort of motions other than like a motion to strike what a witness just said based on an objection. So there's not going to be any motions for summary judgment, none of that. As fun as all that might possibly be for some of you, it's not, we don't have time for it, quite frankly, in this sort of situation. We're also not invoking the rule for sequestering witnesses. The witnesses are all going to stay in the courtroom for the entire trial.
And we had a question, if we can clarify what you mean by motion to strike.
So a motion to strike in this case, this is my assumption anyway, for this particular motion to strike would just be, you know, if a witness started testifying to hearsay, you objected to hearsay, you know, I move to strike that from the record, what the witness just said from the record.
Great.
So, I mean, in that case, it's not really a motion in terms of what we're thinking about, but it is technically a motion because you're moving for something. But that would be allowed. Otherwise, anything else is not allowed. Rule 411, supplemental material costumes. You know, we'd caution you against really trying to wear costumes. I'm not sure any of the witnesses this year really allow for any sort of elaborate costume anyway. But the only material you're really supposed to have is your case and ways to take notes and any notes or preparation materials you may have. You're not supposed to bring in any outside things other than what's in your case file, okay? And the only exhibits obviously that you can present are things that are in the case. You cannot present any exhibits that are not presented to you as part of the case. Independent research relating to case topic. Generally speaking, you can do all the independent research you want if you need to better understand the facts of the case, to understand the rules of evidence, but all of your independent research does not come in. If it's not in a witness statement and it's not an exhibit, it's not presented at trial. If you watched a really cool YouTube video to better understand the rules of hearsay, I understand why you do that. As someone, you know, we all went to law school, we understand how confusing these rules are, but you're not going to get to make arguments at trial based on what you saw in the YouTube video. You're going to be limited to what's in the rules of evidence, what's in the rules for the competition, and what is in the case packet, okay? And should any of your independent research suggest that a fact in the case is incorrect or inaccurate in any way, the case materials control as incorrect as they may be. Okay, so if the materials say, for example, the sky is pink, but you've done research and your research says the sky could never possibly be pink from a scientific perspective, you know, a witness could disagree and say, well, I thought the sky was orange that day, but no witness can testify, well, it's scientifically impossible for the sky to be pink, because that's not in the case. It's not allowed. Okay. Trial communication, this is really important. During your trial, the only people who can be talking to each other are the witnesses and attorneys. Okay, so anybody, any alternates, any coaches, any advisors, anybody who's not on this side of the bar cannot be talking to each other or passing notes in any way. We can see you. I think that's the biggest feedback that I would give. As sneaky as you think you're being, every time it happens, it is seen by the judges because we can see it happening. Okay. And this is just really to make sure that the teams are competing, it stays fair and that no one's getting any extra advantage, no one's getting any extra assistance during a trial. Okay. And that means any observers, coaches, teachers cannot talk to, communicate, or signal in any way during the trial. And this stays in effect even if for some reason we have to take some sort of emergency break for some reason or other. The witnesses and attorneys are expected to stay in their seats, and they can again talk to each other, pass notes among each other, but anybody who's not on this side of the bar can't talk to each other. Okay. No objections can be raised during opening or closing. I would look at this rule really specifically because it does allow for a little bit of argument after the opening and closing is done. If you wanted to try to present some reason why you think an objection was valid, you just cannot stand up in the middle of someone's opening or closing and make that objection. And then rule 4.19 addresses objections. Again, we're going to go through these during our breakout. I would just tell you, go look at rule 4.19. It gives you a lot of objections that are not necessarily in the rules of evidence, but it's also important to know that it's not all of the objections you can make. There are objections based on the rules of evidence that you can also make that are not listed in rule 4.19. So you want to look at 4.19. You also want to look at your rules of evidence and put those two things together. Okay. And then I didn't make a slide for this, but rule 4.20, point 1 and point 2 gives you a really good breakdown on how to introduce exhibits. So if you came today thinking, I don't know how to introduce an exhibit into evidence, you want to go read 420.1 and 420.2 because those are going to tell you how do you introduce an exhibit into evidence. Okay, that's going to give you a really clear guideline for that. And the last, that was loud. And the last thing I just wanted to highlight is rule 6.11, which addresses disputes regarding conduct during the trial. It tells you how to make those rules to allege rules violations, what the process for that is. And generally speaking, you're probably not going to know what the judge's decision regarding a rules violation is. The vast majority of the time it's taken under advisement. The judges can decide whether or not to assess penalty points, if any, and can determine whether or not they think it was an egregious enough rules violation for any further action. But if you have any confusion about like, well, if I think a rule was violated, what do I do? Go read it's all in basically section 6 is going to discuss basically dispute resolution and what to do if you think that the rules are violated. So that was the last thing that I had. Were there any further questions?
There was another question in the chat that I think relates to what you just discussed, which is how will the point system work in the mock trial and what actions can cause point deductions?
That is a much more complicated answer than I think generally speaking, each region has, is entitled to do scoring how they choose. I'll tell you in the Dallas area for the rounds that we run, basically each particular segment is worth 10 points. So a team could have a maximum of, I think, 110 points. Does that sound right, Jamie?
Yes.
Something like that. And, each person for their particular segment. So in opening, for example, you'd be scored between 0 and 10. In terms of rules violations, if there's unfair extrapolation, if someone thinks that it's happening, that could deduct points from a witness. If there's talking across the bar, that could result in general just penalty points assessed, because there is a part where we can just assess penalty points in general. But for the most part, the score is just going to be based entirely on how well the questions are asked, how well the questions are answered, how well objections are raised and handled.
Another question, are we going to go in depth in the process of rebuttals and redirects?
Rebuttals for?
Which I think maybe redirects and recrosses.
I think the rules maybe address that, and I think that's also in the slides for our breakout. But generally, redirect is going to be limited to the scope of the direct and cross, or the cross rather, and then the recross is going to be limited to the scope of the redirect. Is that correct? Does that sound accurate?
Yeah. Yeah, and we'll definitely talk about that a bit in the breakouts.
Yeah.
Another question, any rules regarding volunteer attorney judges recusing themselves if they know the attorney sponsor of a team?
Yeah, we are, well, not necessarily if we know the attorney sponsor, because quite frankly, a lot of us who have been involved in mock trial for a couple of years, you meet people, you start to know names. So it'd be hard to just recuse based on the attorneys, but there is absolutely rules where you're recused if you know a student competing on a team. Basically, we're all required to disclose up front if we know any students competing on any team. And then basically, usually we have enough rounds going that we're able just to have, for example, if a lecturer knew a student competing on a team, she just wouldn't be allowed to score that round at all or be involved in any way with that round. She would be assigned to a completely different round.
Also, it's important to know that unless that person is physically present, we don't know the school the person's coming from. So if I have a friend that I know is working with, I don't know, Plano Senior High School or something, I do not know that team is Plano Senior High School. So there's no way that I can take that into consideration.
That's a great point, because, at least in our region, Region 10 and Dallas ISD runs that we run up here in Dallas, teams are assigned a letter. And so I don't even know, well, I mean, as a member of the committee running the competition, I could look and see, but the vast majority of our judges, all they know is it's team A versus team B. They don't know what schools they are. They don't know anything about them. And so unless the attorney advisor is physically present, again, we probably wouldn't even know. And again, with the COVID restrictions, I'm not even sure if we're going to be able to have a lot of extra people at the courthouse. So that would really limit how we would even be able to identify people. Was there any other questions about any of that?
There was another objections question.
Is there
a limit a limit amount of objections in the courtroom, and what may happen if there was a cross-examination that resulted in a rebuttal that went over time?
Okay, I don't necessarily understand the second part of the question. The first part of the question is there a limit to the amount of the objections? The answer is no. You could object. I guess in theory, if you think you have a valid objection to every question, you could make that objection. I wouldn't, just because you can. So there's not, but objections don't, technically time is supposed to be stopped during objections while the arguments for objections is being made. So there's not really any value to objecting to a lot of things, unless you just think the questions are that bad. There's going to be a lot of foundational questions that are being asked that, I think in reality, a lot of times we have leading questions of well, you live in the state of Texoma, isn't that correct? That's technically leading if you're asking that on direct, but if you object to that, I think you're mostly not going to get the response you want. I don't know, Stacy, did you have any?
I think that's a strategic call, but what I will say is that if you're think about how a juror might view it. If you stand up every 10 seconds, it's not helping your case probably. So just make the strong objections that you think you should. The other, I think on the second part of the question, when you talked about resulting in overtime, like Jessica said, when there's an objection, the clock stops. But if if what happens with the student timekeepers is when time is up, the student timekeepers are going to raise their hand and say that, and then the judge is going to say, all right, everyone sit down. So you don't really need to worry about that.
Yeah, the judge has a little bit of discretion. Like if you're literally, if like a witness is answering a question, the judge may let that witness finish their answer before calling time. But yeah, just because there's been a lot of objections or a lot of back and forth, you're not going to get any extra time. We just, quite frankly, if we started doing that with every round, the rounds would last probably 6 hours, and nobody really, nobody really wants that, especially you guys, to be very honest.
There was another comment about the I guess the recusal. Here's the deal. We all know each other. Like, I mean, I know it seems like Dallas is a large place, but you have a tendency to run into the same people every day. So if your coach is somebody that I ran into at a Dallas bar event or something 5 years ago, and I remember their name and their face, I may not necessarily recuse myself for that. If I am godmother to your coach's child, yes, I am definitely going to recuse myself. So, there is a spectrum there. So just because I may have met your coach or know your coach's name does not necessarily mean that that the judge is recused. I think in previous years that I've done it, we've had enough people where if there was like a tenuous connection, we were able to kind of shuffle some people around to even not give the appearance of impropriety. But again, with all of us kind of being a community in and of itself, we don't always have the luxury of doing that. But definitely, I've always felt that the judges are very good about if they have actual connection to a person in a case outside of a strictly professional one, that they will make everyone aware of that.
I would say don't worry about personal connections and stuff like that. We're all professionals here and we want to score a mock trial competition. There's not playing favorites and stuff like that. So just know that everyone who's judging, all the jurors and the judges and people from the Dallas bar that are participating in the mock trial that you guys are presenting, we're all professionals. We just want to encourage you and support you as you do mock trial. So just know that that's not something that you guys need to worry about. Just present your case and it'll be okay.
Yeah, and just to again clarify, if a judge has a personal connection to students, they are supposed to disclose that up front. In our judge sign up, we have a spot where they're supposed to say what schools that they would be conflicted out of judging. And we have a hard rule on the committee that they do not judge. Like, we would go pull someone off the street to judge that round if necessary before we would allow someone with the conflict to judge it. But it's never been an issue. We always have enough judges and there's enough rounds running at the same time that we absolutely avoid conflicts in that manner. And I believe we even went so far as one year, one of the committee members had a child who was competing and they were not involved at all in running the competition because of that. Just because of that particular conflict. So it's a fair question to ask. Generally speaking, it's not going to be an issue that comes up because we do take that very seriously and we make sure that it's not an issue. Okay, so I'm going to turn it over to Jamie, who's going to run the next segment for us. If you have any other rules related questions, you can throw them in the chat and I'll try to get you guys an answer. And if we're not able to get you an answer today, I encourage you to get with your coaches or advisors who can get with Melissa, who's our coordinator, and she can get you a clarification if necessary. Sometimes we just, redirect people back to the rules because, most of the time the rule is pretty clear. So. All right, Jamie, take it away.
All right. So we're going to be spending a lot of today with us who are former presiding judges, current presiding judges, committee members, talking to y'all about certain rules and certain do's and don'ts about mock trial. But we were thinking it would also be nice to have an opportunity for y'all to talk to each other. And we've got a great mix of intermediate, advanced, and beginner students in this group. And we wanted to ask the intermediate and advanced students to answer some questions that we had that we thought beginner students might also have. So you could have an opportunity to tell each other whether you have 1, 2, 3, 4 years of experience with mock trial, some of the things that you have found really important about mock trial that the beginners are probably wondering. And so what I'll ask is, we've got a couple of questions, and I'll ask if you're an intermediate or advanced mock trial participant. After I ask a question, if you have an answer to that question that you would like to share and you want to put that in the chat, that's great. I don't know if we have the capability of letting people unmute themselves to just talk. I'm just not sure logistically if that's possible. So maybe we'll stick with the chat for now. And then beginner students, if you have follow-up questions or additional questions, feel free to put those in the chat too. And then we'll open it up to the group to answer those as well.
Yes, they can allow themselves to speak, just to let you know.
Oh, okay, great. So yeah, if you're an intermediate or advanced student and you have an answer and you'd just like to say the answer rather than typing it, feel free to unmute yourself and you can just give that answer. That would be great. Okay, so the first question for the intermediate and advanced groups is, what do you wish you had known before your very first mock trial? What's one thing that you wish somebody had told you?
Hey, I'm Jerry. I've been in mock trial this is going to be my 4th year. I'm one of the advanced students. I think something I wish I knew before I joined mock trial is how fun it is, right? Like, I joined because I like law, but I figured it's going to be really time consuming and stress relieving or stressful. But I think throughout my high school career, it's one of the best moments I've had with my team and being an attorney. It's really fun.
That's great. That's always so good to hear. And if I can ask you a follow-up, because it's one of the other questions we had, what do you think is the most fun thing about mock trial?
Traveling and not being like, because in my school, my district, we have clinics throughout the year. So we get to miss a couple days of school, not saying that's bad or anything, but like, it's really fun not having to sit through a stats lecture or like econ instead of like going and eating pizza and learning about like different objections and stuff.
Cool. And we had someone in the chat when I asked the question about what's the most fun part of mock trial, say competition day. David, do you want to add a little to that? If you're able to unmute yourself.
Hi, this is Melanie. I'm on my teacher's computer right now, so that's why my name's David. But I've been in mock trial since my freshman year, and genuinely before COVID, when we went to competition, it was so fun. And I just feel like when you're seeing other schools and connecting and collaborating with them, it's really fun. Even when we did the virtual competition last year, I was able to just have a fun day with my team where we united and were able to compete together. So I think it's really fun that one day to have together.
That's great. And Melanie, were you also the one that put in the chat about how there's many ways to make someone else's team, their time more difficult when they try to ask a question? Or is that a different Melanie?
That's a different Melanie.
Okay, great.
Thank you.
So different Melanie Garcia, do you want to add a little bit to that?
Since I've been playing an attorney and a witness, it's very fun to try to make their questions very, like, when they try to ask a question, it's very fun to make it difficult for them.
Yeah. And I mean, to be honest, from the perspective of the attorney, jurors, and judges, it's really fun for us to see how y'all handle things like that. Because everyone comes at it a little bit differently. And it's definitely something that's one of the most things I would say for us. We had another comment in the chat from Olivia. I personally like how creative some teams get with their witnesses. It's very interesting to see everyone's interpretation of the same fact statement. Olivia, do you want to add anything to that?
Yeah, sorry. I probably would just say that it's really cool to see how really just reiterating my point, it's how creative some teams can get even with little things like their mannerisms or little words that they say just to make their character a little more interesting. I think it's really cool because you can take that and really make it your own, and it makes the whole trial a lot more interesting and a lot less boring.
Yeah, absolutely. Does anyone else have a response they want to share for anything you wish you had known before your first mock trial?
Yeah, so I'm Kushal. I've been in mock trial since my sophomore year. And, I agree with Melanie on the whole competition thing. It's incredibly fun to see how all the different teams come together and how they portray their witnesses. But something I wish somebody had told me before I started mock trial was to not be nervous. I remember showing up on the day of my first competition and I was just like shaking. I was literally like so scared. But now that I've done it a couple times, it's really not that much to be afraid of. It's just, like a competition. It's just friendly. And it's really cool. I like it a lot.
Thank you. Anyone else have something to share? Something you wish you had known before your first mock trial? Okay. The next question that we had for the intermediate and advanced students is, what ended up being more important for mock trial than you originally had expected? And what was less important? Does anyone want to address that?
I'm just gonna go. Hi, my name is Rashida. I've been doing mock trial. This would be like my third year now. And I guess before I got into it, I thought like my main goal was to like win the case, like for our team to win. But I guess like after I got into it and I like learned a lot more about it, it was just trying to get your idea through to like the jury maybe. And it was so much fun to like trying to like make like a metaphor or like a type of theme that we would have throughout our case. And we would like use that for our questioning as well. So I think that's what I found out was more important, just kind of conveying our message rather than trying to win.
And was there anything that turned out to be less important than you thought it was going to be originally?
Because I remember we were trying to learn like objections, and I was so bad at it in the beginning. And for me, it's not as important as conveying your message, but it definitely is important. But yeah, I would say objections, definitely.
Okay. Thank you. In the chat, Francesca said one thing that was more important than expected was being flexible. Francesca, can you add something to that?
Yeah, definitely. So I'm Francesca. This is my third year in mock trial. And I found that, sometimes whether something doesn't go as intended, whether you're trying to enter an exhibit, but an objection passes, or you get asked an unexpected question on cross, or something like that, to where, let's say the witness that you're directing forgets a piece of their witness statement and you have to kind of rework that. So just taking things as they're given to you in the trial, but being able to adapt and kind of overcome what, didn't pan out exactly how you thought it would pan out, but still working to, correct that, I guess. Yeah.
Thank you. And I'll say from a judge's perspective, that's definitely something that we all look for too, because unexpected things can always happen during a mock trial. And we're always looking for how the mock attorneys and witnesses can deal with those unexpected things and how flexible you can be. So thank you for that response. We have another response in the chat from Melanie Garcia. More important would be to take all the time you have right now with no contemplation, because there isn't so much time in competition, I assume, because it goes quick. And less would be on how to pronounce a name, since we would be dealing with many difficulties on how the others say their witness name. So Melanie, I'm going to ask you to elaborate on that, but I just want to say something about your second point, which is the name pronunciation. A lot of times in these mock trial cases, the names are absolutely bonkers, and we as judges have no idea how to pronounce them either. I can't imagine a judge or juror ever marking points off for somebody pronouncing a name differently than how somebody else would. But Melanie, would you like to elaborate more on your first point?
when you're trying to do your questions and you're really focused on doing your questions, and when you're with your team, to take all that time with your team to know how to plot all your questions accordingly for everyone and not do it on the last minute.
Yeah, absolutely. And that leads to a response that we had gotten over email to one of these questions, which was one of the question about what do you wish you had known before your first mock trial? And the response was that you can't communicate with your team during the competition. And that's true in terms of your coach, your attorney advisor. During the actual competition, when you're in the mock trial, you're not going to be able to talk to those parts of your team. And so, as Melanie was saying, it's really important to have done a lot of practice and to really be comfortable with your strategies and everything that your team is planning to do in competition, because come competition day, you're going to be able to communicate with the people sitting at the table with you, but you're not going to be able to communicate with anyone who isn't at that table. So that is definitely something that's important to know, and also something that I think can be a surprise for new participants at times. But that leads to doing a lot of practice ahead of time.
One of the quick things that I would suggest, based on while the pronunciation of the witnesses' names may not be as important, I've seen a lot of people year after year get tripped up on pronouns. Because your witness, they try and make the names as gender neutral as possible, to the extent they can. But on your team, you know, the medical doctor may be male. On somebody else's team, the medical doctor may be female. So, but you've practiced asking the question so much as, you know, Mr. So-and-so, Mr. So-and-so, you know, so just be cognizant of the fact that though in your cross, this person may be one gender, they may be a different gender on another team.
So we had a question in the chat. How many times a week do teams typically meet to practice? And that's something that if anyone would like to address, to unmute yourself and address. I think it really depends on the team, but if you're comfortable sharing about how many times a week your team practices, I think that could be helpful for some of the beginners as well.
So my team, we have an elective period. So we meet 2 times a week during our school's elective period. And then we also have other unscheduled practices outside of school. Like we'll sometimes meet at one of our team members' house, have dinner, go over the case. We'll also meet after school sometimes. So it honestly depends on how devoted to the case you are, how much you want to tighten up your direct crosses and get into the witness characters and just really know the case and bond with your team, honestly.
Okay. Thank you. Anyone else have any input for that question?
Yes. My name is Jasmine Fletcher. I've been with the been doing mock trial for 3 years, and I would say to practice as much as possible, because I know whenever I first came into mock trial, my first year in mock trial as a lawyer, it was always hard to how do I explain it? There would be times where like my witness would get on the stand, and like we've gone over so many times, but then they will forget to say something that's like important information. And so then you would kind of like have to adjust your questioning, because you can't kind of like lead them into what you're saying, like per se, because it would be a leading question. But yeah, just practice as much as possible. That's all I have to say.
I think the input I would have there as well is, you're not always going to be able to meet with your team every time, or even the attorney and witness can't necessarily meet. But if you know you're the attorney assigned to ask questions of witness A, is to read that fact pattern every single day. The witness should be reading it all of the time, so that you both know the facts backwards and forwards, so that no matter what the other team tries to throw at you, you know what the answer is. If the witness on the other side answers in a way that you don't think matches the fact pattern, you're immediately able to sort of confront them when you get a chance and say, that's not what your statement says, so that you're not missing out on those opportunities to ask really good questions on cross. It's just, even if you can't meet as a team, you individually should be looking at your witness statement as many times as you can so that you know those facts cold.
Definitely. There's a related question in the chat, which is, was it hard finding members to join? How did you get enough people to fill your team? Would any of the intermediate or advanced students like to weigh in on that?
I can. When I joined, it was mostly one of my friends who considered me into doing mock trial because they knew that I wanted to be an attorney in the later future. And they advised me to go with their teacher, and I said, okay. And there wasn't too many students in our club, but there was enough to make a team. And we all decided to be at least an attorney or attorney and witness. So it can be hard, but now that we're doing sometimes face-to-face, it's kind of easier to have more students try to be interested. So it's difficult, but it all depends on the student's preference in being in mock trial.
Okay, great, thank you. Any other students have input on that? How you found members to join mock trial?
In my school, during orientation for the freshmen, we do a club fair. And that's how we mostly get our new members. And then throughout the year, because our English 1 teacher is our sponsor for the club or our team. We have her kind of give us a shout out and like
You dropped out. I think you're on mute, Jerry.
Oh,
okay.
What part did you not hear?
You had mentioned your English 1 teacher who's the club sponsor.
So she kind of gives us a shout out. And we partner a lot with the other competition clubs like BPA and TSA in our school, and even like the chess team. And we kind of do like outreach programs throughout the school, and that's how we kind of get a lot of our new members.
Okay, great. That's some good advice. Okay, the last question that I want to throw out there is, what do you all think the judges are looking for in a good attorney or a good witness, based on your experiences?
Someone who's confident, because I've never seen a judge never appreciate someone who knows what they're talking about, and who understands the case and what they're doing.
Great.
And I think that goes for both attorneys and witnesses. Like for witnesses, I think judges might be looking for someone who first like knows their fact statement really well, and second, someone who can step into that character. Because for all like the trials I've done, I love seeing like the people who try to do like an accent, or who like try to, I don't know, show a lot of emotion when they're doing their questioning. And I feel like that might be what judges like to see when they're watching the questioning for witnesses.
Great.
I've got something to add on. It's important to be poised if you're an attorney, and it's important to be very emotional if you're a witness.
What do you mean by emotionful if you're a witness?
Like kind of portray whatever the fact statement says. For example, yeah, just portray what the fact statement says.
Okay. Any other thoughts on that question?
Yeah, I have something to add. My name is Karina, and I am a second-year mock trial student, and I was a witness last year. And I think it's very important to remember to stay calm as a witness, like to not get the attorney get under your skin, and to just like not take things personal, but like remain in your character. And I feel like that also comes with being prepared. And I feel like the judges can see that, like the reason you're relaxed, the reason you're confident in your answers is because you've prepared lots. And I feel like that just shows a lot. I mean, I guess you could say the same for attorneys, that they also have to remain relaxed, but I feel like attorneys have to be a little more assertive in their questions in order to like really
strap down the witness and get them to answer the questions. But yeah, as for witness, I feel like it's really important to remain calm and collected.
Any other thoughts either on this question or any of the questions that we've been discussing from the intermediate or advanced students?
Hi, I'm Chloe. I wanted to talk about the last question about trying to find people. So this is my second year in mock trial, and I was actually recruited my 8th grade year by the girls who are currently on the mock trial team. And then we're given an invitation to kind of see and do like a mock case from the previous year. And that's how I ended up on the team my freshman year. And it's like towards the end of my freshman year, our mock trial team, it's like we look at girls like throughout our classes and girls who are in debate or speech and like sort of invite them in throughout. And then even during competition season this year, my sophomore year, as a former competitor, and even competing now, like other girls who are also intermediates from previous years, we have input and we suggest to our coach, like, hey, this person would be good for that role, or this person seems really fit for this role, or this person seems fit as an attorney. So it's really just about keeping your eyes open and always scanning and knowing like from previous years, like who would fit this best.
That's great. That's really helpful. Anyone else have anything to share?
About being an attorney, something judges are really looking for is a little phrase that my team likes to use called own the room. When you step in, be commanding as an attorney. Your job is to tell the story of the plaintiff for the defense and why you're right, but not tell them why you're right. Make the jury think they figure out from your storytelling, make them make the connection that you're the one who deserves to win the case. And you do that by being winsome, by really commanding the room, commanding respect with your questions, your confidence, knowing your stuff. Those are just a few things that judges are really looking for in a good attorney.
Great. Thank you. Anyone else? Okay. Well, I want to thank everyone for speaking up and adding their responses and questions to the chat. This was great to hear everybody's perspectives. So again, thank you. We appreciate the participation. I think now we're going to take a short break, but before we do that, and we're going to go into breakout groups after that,